This clause is crucial in any subject to purchase and sale agreement. You want to make sure that you've got the seller on the hook. In this video, we're going to cover the risk of a seller bankruptcy when you're buying property subject to an existing financing. And I'm going to give you 3 crucial clauses you need to include in your subject to agreements to protect your investments. All right, so why is it so important about protecting yourself from a seller bankruptcy when you're buying property subject to? Because here's what happens. If the seller, after you've bought the property, files for bankruptcy, remember, they're still on the loan. And what's going to happen is they're going to roll into either a Chapter 7 or a Chapter 13 bankruptcy where a trustee is going to be appointed to oversee their financial affairs. And the trustee will see that the seller entered into this subject to transaction with you, and then the trustee's job is to determine whether or not it's in the creditor's best interest to sell you the property. Because that trustee has the authority to challenge or even void the transaction if they find that it's considered to be a fraudulent transfer, preferential payment, or an undervalued sale. So, if that happens, in order to proceed forwards, you're going to have to get court approval. That means you got to go to court and you have to obtain from the bankruptcy court the ability to continue with this purchase of this property, where you'll have to prove that the transaction is fair and equitable. And in addition, the court could impose additional terms or conditions on the sale, which could affect your investment. Most notably is you may have to bring money to the table, of course, to buy this property out of bankruptcy. And the thing about bankruptcy and subject to transactions with sellers is that it's a lengthy process, and you have to obtain court approval for the transaction, which can take time and result in significant delays in the closing. You're having the ability to control that investment, to sell the investments. Worse yet, the trustee will collect potentially all of the rents coming in off that property. In addition to that, I mean, you're probably wondering, why would you ever do this? Well, a lender is going to be notified and they could enforce the due on sale clause, which means, as I stated earlier, you got to be ready to pay off this property or have someone lined up that can loan you the funds to pay it off. Now, can you protect this? Well, there's a few things you can do in your purchase and sale agreement on subject to transactions that can minimize the risk for you in a seller bankruptcy. So the first clause you're going to want to have in there is an indemnification clause. And so what this indemnification clause is going to do is make sure that the seller indemnifies you for any losses you have as a result of the seller filing for bankruptcy. This clause is crucial in any subject to purchase and sale agreement. You want to make sure that you've got the seller on the hook, because you could buy that property and you're sitting there paying the mortgage down for 3 or 4 years, and all of a sudden the seller determines, hey, I'm going to file for bankruptcy. And it throws everything that you have into disarray. So if you suffer damages as a result of that, and the bankruptcy trustee steps in, you have to hire an attorney, you want to be able to go back against that seller and hold them liable. I know they're in bankruptcy, but if you want to have that in there. The second clause you want to have in there is a right of first refusal. So here's the idea. If the trustee takes back the property and then they want to sell it to someone else, well, you have a privity of contract there. So you want to make sure that that bankruptcy trustee gives you the first right to purchase it. So if they get an offer from someone else, maybe it's a little above your offer, you can step in front of them with that right of first refusal and buy that property. Now, the last clause is going to be what I refer to as a bankruptcy contingency clause, which is kind of a all-encompassing clause. It states that you get additional remedies against the seller if they file for bankruptcy. And it's really designed to say, hey, if you try to terminate this agreement by going to and filing for bankruptcy, then I have the right to seek legal recourse against you beyond just the indemnification I could seek in the event of that type of transaction. Now, again, they're in bankruptcy, so a lot of this is going to depend on how that process plays out, but it's in your best interest to have these types of clauses in your purchase and sale agreement if you're investing subject to, because you already know many times that that seller is in a distressed financial situation. So you need to do everything in your power to protect your interest. If you want to learn more about how to put a plan into action and properly structure all of your real estate investments, you can register for our free Tax and Asset Protection live event at the link below. And on this event, you're going to learn how to use limited liability companies, corporations, land trusts, as we deploy those in various investing strategies. More importantly, we're going to bring in the tax side of investing, because that is where things get really interesting, that actually owning real estate can pay you back money on an annual basis, just from the taxes alone. But if you're a real estate investor and you're trying to wonder, how do I apply these strategies to me? We've got you covered, because on this event, we'll have a team of attorneys and CPAs that will be there answering your questions live. I hope to see you there, where you'll learn a ton of information when it comes to tax and asset protection for real estate investments.